Hi, I am Debbie Reiki. I'm a Senior Associate and Solicitor Advocate at Brodie's, and today I'm going to speak to you about transgender rights in Scots family law. Trans is an umbrella term which encapsulates a diverse spectrum of gender identity. Broadly, it describes a person whose gender identity does not conform to the sex assigned to them at birth. Sex being the traditional view of binary, biological, anatomical, chromosomal attitudes of male and female, and gender being the socially constructed roles, behaviours, expressions, and identities of individuals. Domestically, our response to trans-related family law matters have evolved over time. Today, I am going to talk through some of the provisions of the Gender Recognition Act 2004, the Gender Recognition Reform Scotland Bill, parental rights and responsibilities for transgender parents, gender identity and divorce or dissolution, assisted reproduction for transgender parents, and lastly, adoption for transgender parents. Legal recognition of gender identity in Scotland. The Gender Recognition Act 2004, which applies in Scotland, established a legal framework in the UK for transgender people to change their legal gender. The Act came into force on the 4th of April 2005. It allowed, for the first time, individuals over the age of 18 in the UK with gender dysphoria to change their legal gender. Under the 2004 Act, individuals who have lived in their acquired gender for at least 2 years can apply for a gender recognition certificate. This certificate allows the person to be legally recognised as their self-identified gender across all areas of life and enables them to obtain an updated birth certificate, marry or form a civil partnership in their gender, and have their gender recorded on their death certificates. I'm going to talk through not all of the Act, but some of the main provisions. Section 1 deals with applications. It provides that a person of either gender who is aged at least 18 may make an application for a gender recognition certificate on the basis of A, living in the other gender, or B, having changed gender under the law of a country or territory outside the United Kingdom. Subsection 2 provides that in this Act, the acquired gender in relation to a person by whom an application under subsection 1 is or has been made means A, in the case of an application under paragraph A of that subsection, the gender in which the person is living, or B, in the case of an application under paragraph B of that subsection, the gender to which the person has changed under the law of the country or territory concerned. Section 3 provides that an application under subsection 1 is to be determined by a gender recognition panel, and subsection 4 provides that Schedule 1 gender recognition panels has effect.